Thank you, Mr. Chairman. Ms. Rao, there's been a great deal of discussion about your college writings, which I would agree are, at the very least, cringeworthy and have deserved and gotten a great deal of attention. I want to submit for the record, if I could, Mr. Chairman, a letter from 54 South Asian American women who are civil rights attorneys, who are law professors, who are advocates for survivors. It at length challenges some of the assumptions in your college writings. But that's not what I want to focus on today. I want to focus not on things you wrote decades ago, but your view of executive power, and in particular the unitary executive theory, and how, not in college, in the heated exchange of campus politics, not even as a law student or law clerk, but after completing all of your legal training as a professor, I think at the time, you wrote a law review article in 2014. Where you talk really very pointedly about your sense of the scope and reach of presidential power. Briefly, I'll quote, "The president must have the ability to remove all executive branch officers at will," and then you go on to explain just how broad you think that power is. Let me just put a point on this. Do you believe the president can fire at will a federal prosecutor who's investigating him, his family, his campaign team, his senior advisors? Do you think the executive power goes that far?
Well, Senator Coons, in that article, I was writing primarily about the president's control over civil cases, over the administrative state and administrative agencies. You know, the question of removal power in that context is not one I have written about or looked at closely.
Well, I appreciate that answer, but it doesn't strike me as really answering my question. You may have there been speaking to civil, not criminal, but the force and clarity with which you assert the reach of executive power overall, even including independent agencies, strikes me. To quote from that same law review article, "The Supreme Court has repeatedly recognized all agencies, including the independent ones, are part of the executive branch." You go on, "The president alone possesses the power to direct, control, and supervise inferior officers or agencies who seek to exercise discretionary executive power." Wouldn't the special counsel be part of the executive branch?
Well, Senator, respectfully, that is, an ongoing matter of political controversy and also could potentially lead to lawsuits. And as a judicial nominee, it wouldn't be appropriate for me to comment on those issues.
So is it your view that Congress can't place any restrictions, even ones that put in statute what are currently regulations that protect a special counsel from removal by the president?
Senator, I did not argue that in my articles. I did not.
Would that not seem an obvious and logical conclusion from a view forcefully and repeatedly asserted that the president should be able to remove even the heads of independent agencies?
Well, Senator, one of the things that I try to explain in that article is that there are competing interests, right? Congress has a lot of important authorities under Article 1 to create agencies and to set their powers, to set their different authorities, and that has to be balanced against the president's responsibility for overseeing the executive branch. And so that I recognize in the article Congress's important interests in those areas.
Well, and I was going to call him Professor Lee. Senator Lee, my colleague, previously questioned you about whether or not tyranny results from an overreaching administrative state. I would posit that an equal and comparably valid concern is the tyranny that might result from an overreaching executive, something I think was much more at issue in our founding. Let me just briefly turn to Morrison v. Olson, a Supreme Court case from 1988 with which I'm sure you're familiar, where Justice Scalia, in a single dissent, expounded this unitary executive theory, which has gained credence and followers. You may be at the head of that pack in the decade since it was handed down. Would you agree with me that your theory of unfettered removal power, expounded in that 2014 law review article, was expressly rejected by the Supreme Court majority in Morrison? Is that not clearly the holding of the case?
Well, I think that yes, Morrison v. Olson does recognize, some important limitations on the president's removal power.
And is Morrison still good law?
It has not been overruled, so it is a binding precedent of the Supreme Court, which I would follow if I were confirmed.
What's the view of the D.C. Circuit of Morrison?
The D.C. Circuit has upheld the validity and recognized that it is still good precedent.
How recently?
I think quite recently.
Quite recently, I think, in fact, last year. And so I'm troubled, I have to say, not just by that 2014 law review article, but by a 2011 law review article where you're going through Free Enterprise Fund versus PCAOB and suggest, and I quote, that Supreme Court opinion strongly suggests statutory limits on the president's removal power, such as those protecting the officers of independent agencies, are unconstitutional. Let me make sure I get this right. Do you believe that the Constitution allows the president to fire, for example, the chairman of the Federal Reserve whenever he wants, even to influence monetary policy for his own personal or political benefit?
Well, Senator, again, those questions are ones that depend in part on the particular statute at issue and the types of protections it provides. And those were comments I made as an academic commentator and scholar, where I was able to write about the law in the abstract. And I very much understand that it's a completely different role when one becomes a judge and needs to decide specific cases and controversies according to the law and precedents.
Well, Ms. Rao, I think, alarming writings in college aside, I think very recently in law review articles, you've laid out clearly and forcefully a view of executive power so overreaching and so outside the mainstream as to be truly alarming to me in terms of its potential consequences for the scope and reach of executive control and executive power. And while I respect your refusal to answer directly, given some of these things are current controversies, I also have to say, in the context we currently find ourselves in, these are no longer merely academic questions. Thank you, Mr. Chairman.